It's the Attorney General. Mr. Attorney General, welcome to the Senate Labor Committee.
Thank you, Mr. Chair, and thank you, members of the committee. Good evening, Senators. Thank you for giving me an opportunity to testify on behalf of Senate Bill 195. I also want to thank Leader McCaffrey for sponsoring the bill. This is a bill which has been a priority, frankly, in some form for this office now for going on 2+ years. Wage theft and misclassification is a critical issue in this state, and it is frankly, not only is it a critical issue, it's conduct that we can't reach effectively through the criminal justice system. So let me describe exactly what I mean by that. There are cases, and we know that they're out there because we've prosecuted them. We brought 3 cases to date, and there are more investigations pending, where individuals are either stealing wages from their workers, literally stealing wages from them, not paying them, not paying overtime where it's warranted, but again, simply not paying them wages for hours they've worked. We have these cases in the state of Rhode Island, and there are more than a few. We also have cases within the state of Rhode Island which involve misclassification of workers, which, as you know, is classifying an employee as an independent contractor. And the reason to do that is simple. It saves money for that employer. It prevents them from paying benefits. It prevents them from having to comply with fair labor standards. It prevents them from paying Medicaid and other state payroll and federal payroll taxes. It saves them money when in fact they exercise the kind of control over the worker that is consistent with and is in fact an employer-employee relationship. That costs the state money, it costs the worker benefits, and it is completely unfair to workers, to businesses that are playing by the rules. So this legislation, in my view, is, and we hear this sometimes, is not at all anti-business. It is in effect pro-business and pro-worker. Businesses that do it the right way are competing on a level playing field, as it should be, and workers are getting the wages that they're entitled to. By changing the penalties in the statute to felonies, it will accomplish a couple of things. It will make this kind of theft consistent with theft in other contexts. So if you were to obtain money under false pretenses to the tune of $1,500 or more, that would be a felony in the state of Rhode Island. If you were to embezzle $1,500 or more, that would be a felony in the state of Rhode Island. When you're stealing somebody's wages, it's not. And that just makes no sense, and it's not right, and that's what this bill would remedy. There is one other practical effect of this conduct not being a felony. That is this: we cannot use the grand jury to investigate it. And in these cases, which tend to be document heavy, where we need to subpoena records or obtain records, if you will, from an employer that is either stealing wages or misclassifying its workers, or if we need to put witnesses under oath to get their testimony, because it is right now a misdemeanor, we are prevented by law from using the grand jury to investigate the case. That makes it very difficult to do a comprehensive investigation in these kinds of cases. And that is something that you may not hear from anyone else because no one else is trying to do these cases or prosecute these cases, but I can tell you that is a significant impediment to getting the job done. The other thing is we have a case pending right now where 2 individuals who stole wages from their employees are no longer within the state of Rhode Island. We know exactly where they are, they're out of state, but we can't extradite them back to Rhode Island because the warrants are out on misdemeanors. If those were felony warrants, we could extradite them back to the state of Rhode Island and pursue justice on behalf of the victims. We can't do that because this crime is not a misdemeanor. I'm somebody who believes that there are times when we over-felonize conduct. Some of you have heard me talk about that before in the context of drug policy, but this is not one of those places. This is one of those instances where making this conduct, theft of wages from a worker, cheating vis-a-vis other employers, ought to be felony conduct. And I think that this bill, by making that change, would advance the causes of workers, businesses, and the taxpayers alike. And so I would ask I would ask that the committee give strong consideration to this bill and strongly consider passing it out of committee. Thank you, and I'm happy to take any questions you may have.
Thank you, Mr. Attorney General. Are there any questions from the committee?
I have a question.
Senator Golden.
Thank you. Thank you so much for the testimony. I really appreciate it. My question is really more that just from years of hearing different bills with different amounts of money in them, it seems to me that often it's an arbitrary dollar amount that's not actually, it's connected to maybe this particular period of time, but it doesn't necessarily increases minimum wage or average wages increase or that kind of thing. So is the $1,500 only because that's what the felony level is in other laws, or is there some particular reason to pick that as the dollar amount?
Yeah, Senator, that's really the thinking behind it. I can tell you, as somebody who was a prosecutor in this office from 1996 to 2002, the threshold then was $500 for most theft crimes involving a monetary amount, meaning the monetary amount made a distinction between a felony and a misdemeanor. Obtaining money over under false pretenses over $500 was the felony crime back when I was here many years ago. So it has obviously moved up to keep track, with inflation and as our economic circumstances change. So to me, there's no real magic in that number, but it really was drawn because that's where we draw the felony misdemeanor divide in other theft contexts.
Thank you.
You're welcome. Thank you.
Are there any other questions? It appears not. Thank you for your testimony, Mr. Attorney General.
Thank you, Mr. Chair and members of the committee.
And have a good evening.
Good evening.
That concludes the testimony on S-195. Do I have a motion?
Mr. Chairman, I would move passage of this bill.
The motion for passage, do I hear a second?
Second.
Motion made and seconded. Any discussion? Being none, Mr. Clerk.
Senator Burke.
Yes.
Senator Dela Cruz. No. Senator Golden.
Aye.
Senator Lombardi.
Yes.
Senator Picard. Senator Sosnowski.
Yes.
Chairman Chacon.
Yes.
Motion passes.
It appears that Senator Picard is still on, but I thought I heard something, but I'm not sure. Okay. And Senator Dela Cruz?
I meant to vote yes. Excuse me, I was looking at 139.
Oh, okay. So that bill will move to the floor since it was passed. Okay.